My dear students, today I would like to explain to you the basic concepts coming under the Contract Act. I am going to define what is contract and how the Contract Act classifies the contracts. That will be today's explanation. Now, definition of contract. Anson says, William Anson defines a contract as a legally binding agreement by which rights are created by one party to acts or forbearances on the part of the other or others. Please explain in simple words. I will explain. It's a legally binding agreement. Both people must mentally agree. Otherwise, there won't be identity of mind. So, agreement, mentally both of them should agree. Who are those two persons? The offerer and the offeree. So, William Anson defines is a legally binding agreement by which rights are created by one party to acts or forbearances. Forbearances means refraining from doing anything, abstaining from doing anything. So that is what is known as forbearances on the part of the other or others. Therefore, here we must understand the definition. Now, technically speaking, under Section 2H of the Contract Act, the Act defines an agreement enforceable by law is said to be a contract and it is a valid contract. Then the question arises, what is meant by agreement? Agreement has again been defined under Section 2E of the Contract Act. Every promise and every set of promises forming mutual consideration for each other is an agreement. No, sir, I am not able to follow what you say. Supposing I am asking you to paint a picture. A proposal is mooted out by me. Mr. So-and-so, would you like to paint the picture? Yes, sir. What does it mean? You have accepted to paint that picture. So, offer is made by me and you have accepted. Then automatically you ask, sir, what is the price you will give for that work? You cannot do it freely. You cannot do it for gratis. And therefore you have got to get some consideration. This is what is known as price. You cannot do it freely. You have got to purchase paper. You have got to purchase color pencil. You have got to take your own time, precious time, to paint that picture and the labor which you have got to expend. And these things actually require some sort of remuneration. That is what is known as consideration. Every promise and every set of promises forming mutual consideration. So, what is it that the offerer wants? He wants the picture. What is the offeree wants? That is the person who paints. He wants remuneration. So, both of them are supporting each other. Here is a person who wants picture. Here is a person who wants money for doing that work. This is what is known as consideration. So, promise plus consideration is equal to agreement. Now, what is that agreement? When does it become a contract? Agreement becomes a contract when such agreement is enforceable by law. All agreements are not contracts. All obligations are not contracts. All contracts are agreements and obligations. The Contract Act is not going to deal with agreement with surrender rights. The Contract Act is not going to deal with agreement with assigned rights. The Contract Act is going to speak about agreement which creates, defines, protects, preserves rights and obligations. Therefore, you should understand the Contract Act is going to speak only about such of those agreements which are enforceable by law. Now, automatically you will ask me again, sir, what type of agreements are enforceable by law? That's the next question you will ask. Now, all agreements or contracts, if they are made by free consent by competent parties for a lawful consideration and for a lawful object. That is what Section 10 of the Contract Act says. In other words, I would mathematically say C cubed plus O. Sir, what do you mean by C cubed? C stands for first consent. Next C stands for competency. Next C stands for consideration. Then O stands for object. So C cubed plus O is equal to contract. So all agreements or contracts, if they are made by free consent, by competent parties, by a lawful consideration and for a lawful object, this you should remember very clearly. So this is the definition. Next important thing is, the Contract Act has got two divisions, as I have already explained. One speaks about general principles of the contract, the definition, how the contract is formed, how it is executed, how it is discharged, if there is a breach in fulfilling the obligations under the Contract Act, what are the remedies that are available. So these are all the aspects which are dealt with under the general principles of the Contract Act. And you have got the special contract. The special contract are going to deal with special transactions like contract of indemnity and guarantee, contract of bailment, Sale of Goods Act, Partnership Act, Negotiable Instrument Act, Insurance Act, and Railways Act, Carriage of Goods Act, Insolvency Act, so on and so forth. The branches of too many. It is developing day by day. So these aspects, they all come under the category of special contract. Now let us analyze the ingredients for formation of a contract. It is humorously said, even if you want to prepare badam halwa, the ingredients are required. Almond seeds are required, sugar is required, ghee is required, milk is required, elchi is required. So these are all the ingredients that are required for formation of a simple badam halwa. If you want to form a contract, well, lot of ingredients are required as I have just enumerated just now. What are the requirements for formation of a valid contract? That is a predominant question. For the formation of a valid contract, you need offer. Offer means proposal. Such offer, mere offer is not enough. It must be accepted. When an offer is accepted, it becomes a proposal, it becomes a promise. When an offer is accepted, it becomes a promise. So mere promise cannot be enforced. Promise must be supported by consideration. Then only it becomes an agreement. So what is agreement? When two parties are agreeing mentally, either to do an act or not to do an act, it is an agreement by mutual consent. So here, a proposal when accepted becomes a promise. Promise when supported by consideration becomes an agreement. Mere agreement cannot be enforced. It must be enforceable by law. For the purpose of enforcing any agreement under law, there must be mutual consent. Mutual consent. In other words, it is what is known as consensus ad idem. That means identity of mind. When party means one thing, the other party understands a different thing, there is no consensus item at all. So consensus ad idem means identity of mind. Consensu, that is what they say. So there must be consent. For the purpose of consensus ad idem, there must be consent. Consent by both the parties. Second, such parties must be competent. A person who is an insane person, a person who is a drunkard, he is not fit to give consent at all. See, a person who is said to be competent person, a person is said to be competent when he is mentally alert and physically fit. So, when you give a consent, you must give such consent knowingly, feelingly and willingly. the importance of consent. Consent must be free. What do you mean by free consent? Free consent means genuine consent. Consent must be genuine. Consent must be given. It is wrong to say, I have obtained his consent. How did you obtain? By force? By threatening him? By undue influence? By leading him to mistake? By misrepresenting facts? Such questions will arise. Therefore, consent must be given. That is why we say volition. Volition means option, choice, mentally. He should give freely his consent. So, free consent has been defined under section 14 of the Contract Act. Consent is said to be free when it is not caused by coercion, that means force, as defined under section 15, undue influence as defined under section 16, fraud as defined under 17, misrepresentation as defined under section 18, mistake subject to the provisions of section 20, 21 and 22. Therefore, consent is a very, very important. There cannot be agreement without consent. What is agreement? Agreement. Mentally, both the people agree either to do an act or not to do an act. So, mental agreement must be there. This is what is known as technically as consensus ad idem, identity of mind. Section 13 defines what is identity of mind. Identity of mind has been defined under section 13 as follows. Now, section 13 says, two or more persons are said to consent when they agree upon the same thing in the same sense. What you mean, you must be able to convey. What you convey, the other person must be able to understand your intention. Both the parties must agree to the common intention. So when you utter something, when it is understood in a different way by the other, there cannot be consensus ad idem. When I want to sell the house at Bangalore and you think that you are going to purchase the house at Mangalore, now what a colossal difference of opinion that is there. You have understood in a different way. You have understood the house at Mangalore, whereas I mean the house at Bangalore. So, identity of mind is very important. Consensus ad idem or consent is based only on identity of mind. So, every agreement is a contract provided it is supported by consent by competent parties. Who is a competent party? A person is said to be a competent party when he is mentally alert and physically fit. Mentally alert means what? Sound mind. He must not be an insane person. He must not be a drunkard person. He must not be a person who has lost his conscience. Therefore, here competent parties means legally competent. One who is physically competent will not even be considered. He must be legally competent. Law says who are the competent person? A minor is not a competent person. Who is a minor? A minor who has not completed the age of 18 under the Indian Majority Act of 1875, and one who has not completed the age of 21 under the Court of Wards Act of 1890. Therefore, a person must be competent. Competent means who must be legally competent, who must be capable of enforcing his rights against others, and others must be capable of enforcing their rights against this person. So, he is said to be a competent person. So, all agreements are contracts if they are made by free consent, that is genuine consent, by competent parties for a lawful consideration. Very, very important. Lawful consideration means what? Any consideration that is in the form of price or money that is payable over the table, not under the table. If any money is paid not legally but surreptitiously, this is what is known as corruption. Corruption is not consideration. It is tainted. Tainted means it is sullied. So, lawful consideration. And for a lawful object. The object must be lawful. I cannot enter into an agreement to murder X and I will give him money, you please murder so and so. Or I cannot give money to a person to smuggle gold into India, violating the Customs Act and rules and regulations. So the object is considered to be tainted with illegality. That is why you find here the section under the Contract Act 10 says all agreements or contracts if they are made by free consent by competent parties for a lawful consideration and for a lawful object. Mathematically speaking, you can say it is C cube plus O is equal to contract. C stands for consent, C stands for competency, T stands for consideration, and O stands for object. So C cube plus O is equal to contract. So all agreements are enforceable if they are made by free consent by competent parties for a lawful object and a lawful consideration. So all agreements are not enforceable when it is not supported by these ingredients. So that is why Solomon has clearly explained what is contract. The law of contract is not going to deal with all types of agreements, nor it is going to speak about all types of obligations. It is going to deal with such of those agreements which create obligations and such of those obligations which have got their source in agreement. I already explained. Now coming to the classification of contract. Now that is very, very important. This is the basic structure that must be understood by all in order to apply the niceties and nuances under the Contract Act. Now what is the classification? From the point of view of classification, contracts can be classified as follows. From the point of view of validity, you have got the valid contract. What is a valid contract? Agreement enforceable by law is said to be a valid contract. Section 2H. Then you have got void agreement. What is void agreement? Agreement not enforceable by law is said to be void. Agreement not enforceable by law is said to be void. Section 2G. And what is void contract? Here, void contract, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. No, sir, I am not able to follow. Section 2J says a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So there is a difference, lots of difference between void agreement and void contract. What is said to be valid at the time of formation subsequently becomes void when it is not enforceable. Best example I can give you is, today we enter into a contract with China for purchase of tea. Now what happens at the time of formation, both India and China are friendly nations and there is no war between India and China. God forbid. Supposing war emanates tomorrow, when there is a war between India and China, what happens to the agreement which we have entered into prior to the commencement of war? It becomes void. A contract which once made becomes void when it ceases to be enforceable. That is why it has been aptly worded, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So that is void contract. What is void agreement? There can never even be an agreement. You cannot enter into an agreement with an insane person. You cannot enter into a contract with a minor. You cannot enter into an agreement with a minor. An agreement with a minor is ab initio, right up from the beginning is said to be void. Why minor minor's agreement is void because minor is not a competent person under law. Who is a competent person under law? One who is capable of enforcing his rights and rights are being capable of enforced against him. He alone is the competent party. So all persons are not persons. A minor is not a person. Unless he is a person, you cannot enter into an agreement at all. Therefore, an agreement is said to be void when it is entered into by a person with an incompetent person. So a void agreement. So you must understand valid contract, void agreement, void contract. Then what is voidable contract? A voidable contract has been defined under section 2I. An agreement which is enforceable by law at the option of one party but not at the option of other or others. That is what it says. Technically, you will not be able to understand it properly. I will explain from the point of view of common sense. Now, what is voidable? Voidable means avoidable, optional. See, when a person has got a choice to refrain from entering into a contract later, it becomes voidable, avoidable, optional. It is left to the option of a person either to enforce it or not to enforce it. Supposing a person has obtained my consent under coercion, naturally it is said to be wrong as per section 14. It is not genuine consent. Now I have got the right to say, to lodge a complaint in the police that my consent has been obtained by coercion, forcefully. I was threatened to give my consent. I can say that. So the choice of avoiding the contract, the choice of rescinding or rejecting the contract is left to the option of the person who has given the consent under force. So not the person who enforces the contract. It is not left to the person who has actually coerced or who has obtained the consent by force. He has no option. That is why the section has been rightly worded under section 2I. It says an agreement which is enforceable by law at the option of one or more parties but not at the option of other or others. The choice is not given to the person who has entered into a contract by compelling the other to give his consent. It is only the person who has given the consent under duress or under force. He is given the option. That is why it is avoidable by him. You know that equity principle you have understood. He who seeks equity must do equity. He who comes to court must come with clean hands. He who has infamy on his lips cannot touch the fountain of justice. Therefore, a person who has obtained the consent by fraud or by force, he cannot take advantages over other. He cannot take advantage over the other and enforce the contract. Have you understood? So, this is how it has been beautifully worded. So, there is a valid contract, void agreement, void contract, voidable contract, unenforceable contract. What is unenforceable contract? A contract which cannot be enforced. That is what is known as unenforceable contract. So, when a contract cannot be enforced, section 2J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. That is also an unenforceable contract. Unenforceable contract means what? When the technicalities are not complied with. If you want to enter into an agreement, the agreement must be in the proper format and it must be in the proper paper. It is strange that so many people do not understand the difference between judicial stamp and non-judicial stamp. A mere agreement or terms and conditions on a white paper, you file it in a court of law. Will the court will be in a position to enforce it? Certainly not. It is not properly printed on a stamp paper. That is what it will say. It must be typed on a stamp paper. What type of stamp paper? Non-judicial stamp paper. Judicial stamp paper means what? When you want to file a plaint in a court of law, you have got to pay court fee. That is what is known as judicial stamp. For the value of the suit which may pertain to a property or enforcement of a claim for damages, you have got to pay necessary court fee. That is why it is known as a fee. It is not a duty. Fee is, there is consideration, license fee, court fee. They are rendering some service to you. Duty is you have got to pay the duty to the government, revenue to the government, revenue raising, revenue protecting, and so these are all the various types of revenue. Levy that is there, compensatory revenue. So these are all the various types of duties that are paid. So a stamp duty is a duty that is collected by the state. It's an extraction of money by the public authority from a public person for a public purpose. So that is how you must know the difference between duty. It is enough if you understand that much. So unenforceable contract. A contract cannot be enforced for want of technical formalities. If it is not engrossed on a duly stamped paper, or if such agreement is not in the proper format, it cannot be enforceable by a court of law. That is what is known as unenforceable contract. So, from the point of view of classification, you have got validity. From the point of view of validity, particularly under the classification, a valid contract, a void agreement, a void contract, a voidable contract, unenforceable contract. These are the 5 aspects you should be thorough. And from the point of view of formation of the contract, you have got express contract. Such express contract may be in writing, a written contract, or it may be implied or tacit. An express contract, an implied contract. Implied contract means law implies a contract which may be expressed or tacit. And you have got certain contracts which are known as implied contract. Implied contract is quasi-contract. Express contract, which may be a written contract or oral contract. Implied contract, implied may be a tacit contract. Implication by conduct, implied contract. And then you have got to understand implied contract also conveys the same meaning as quasi-contract. Express contract, from the point of view of formation, express contract, implied contract, and tacit contract, and these are the various types of classification which you get under the formation of the contract. Now coming to the performance of the contract. Under the performance of the contract, you have got bilateral contract, unilateral contract, executed contract, executory contract. Sir, what do you mean by saying there is bilateral contract, there is unilateral contract, executed contract, and executory contract? We will explain it one by one. First, let us understand from the point of view of formation, express. Express contract is you express orally. See, even expressing orally, sometimes it becomes a contract. There are certain customs and all that. Take for example an auction bid. When a person bids for a higher price, it is only expressed. So it becomes a contract when once it is accepted by the auctioneer. So express contract. Then written contract. You know, when it is written on a paper, everything we wants to be reduced in black and white on paper. That is why it is a written contract. What is a tacit contract? A tacit contract is a contract that is inferred from the conduct of the parties. What is conduct? Conduct of the buyer's behavior. You can understand he has entered into a contract. For example, when a person gets into a bus bound to Majestic Circle, what does it mean? He would like to travel up to Majestic Circle. So the very moment that he has got into the bus, it signifies his acceptance to accept the offer made by the transport service. And then immediately the conductor demands for the ticket price. So he gives the price for traveling up to Majestic Circle. This is what is known as tacit contract. If a person stands in a queue in a cinema You need not ask him, sir, have you come to see cinema? The very fact that he stands in the queue signifies that he has opted to see a cinema. There is no need. It is what is known as tacit contract. Then you have got implied contract. Implied means what? Law implies a contract. Implied contract is also known as quasi-contract, which Halsbury's Laws of England defines it as constructive contract, certain relation resembling those of contract. What is the best example you can give for that, sir? Section 72 of the Contract Act. Finder of the lost goods, one who finds the goods belonging to the other. What is his obligation? He has got to immediately entrust it to the owner or to the police station nearby and hand over the costly thing so that the owner can be traced and the goods can be handed over to him. So, does the law say like that? It need not be said. It is implied. It is understood. So, that is what is known as implied contract or quasi-contract. So, then you have got performance. From the point of view of validity, from the point of view of formation, we have said express contract, oral or written, tacit contract or implied contract. Now, from the point of view of performance, executory contract, executed contract, unilateral contract, bilateral contract. What is unilateral contract? Nobody has understood it properly, even books. Where unilateral contract has been defined under very many books, where one party alone is under obligation, whether the other party is able to enforce it. This is what is known as unilateral contract. Unilateral contract, normally it is defined, only one party is under obligation, the other party is able to enforce it. It is unilateral contract. That is how it has been defined. To define it properly, you must say that every law has got two aspects, namely rights and duties. Now, what is unilateral here? When rights alone are given to a party under an agreement with no corresponding obligation towards the other, it is what is known as unilateral contract. Invariably, you find government contracts are unilateral contracts. You find government are always in an upper position. So they are in a position to enforce it, but whereas the party is not in a position to demand enforcement. So you find there is unilateral contract where one party alone is able to enforce his right, the other party is not able to enforce his right against the other. For example, take a rental deed in which the landlord says you must pay the rent on or before 10th of every succeeding month, and so far as electric repairs are concerned, you have got to do it by yourself. If there is any other amenities that have got to be attended to, you have got to spend from out of your pocket and you have got to do it. I will not reimburse you. Well, this is unilateral contract, which is not legally correct. So you have got only right to collect the rent but no corresponding obligation to attend to the needs of the tenant. Well, this is unilateral contract. So this is what is known as unilateral contract. Bilateral contract is the contract is poised. It is balanced. Rights and obligations are balanced very nicely. Every duty has got a corresponding right. Every right has got a corresponding duty. This is what is known as bilateral contract. So unilateral. Then executed contract, executory contract. It is a misnomer to call a contract as executed contract. Can you call a person as executed person? When once a person has been executed, he is no longer a person. It is a misnomer. Supposing a person who begs at your house and says, please give me money, sir. What is your name? My name is Kotishwaran. It is a misnomer. Likewise, in Contract Act, you find executory contract and executed contract. Executed contract is a misnomer. What is an executed contract? When the party has discharged his obligation, when the other party also has discharged his corresponding obligations and duties, well, the contract becomes discharged. You cannot call a discharged contract as an executed contract. Executed means fulfilled, obligations have been fulfilled, rights have been exercised. That cannot be executed. You cannot call it as a contract. Contract is no longer there when once it has been fulfilled. So what do you mean by saying executed? Contract for executed consideration. Contract for executory consideration. Contract for executed consideration means what? Supposing Shashank wants to go to Majestic Circle. He hires an auto rickshaw. In that auto rickshaw, the fellow will say, sir, I am switching on the meter. You have got to pay the meter. So what happens now? Then Shashank travels. Shashank never pays any money. Only at the destination, namely Majestic Circle, the meter shows you have got to pay about 89 rupees. So he pays 90 rupees. So for the services that has been rendered by the auto rickshaw fellow, our passenger Shashank is going to pay him 90 rupees. So already services should have been done. When will you pay the porter in a railway station? Only when he keeps the luggages inside the compartment. Before that you will not pay. So this is a contract for executed consideration. Executory consideration means what? Executory consideration means a contract for executory consideration means both the parties enter into a contract. I will pay this much of money. You have got to paint this picture and you have got to give me the picture. You have got to give the picture before such and such date. Both of them bilaterally, mutually agree with each other date as to when the picture has got to be supplied, as the date when payment will be made. Cash and carry. Or advance you pay certain amount. So this is known as contract for executory consideration. So bilateral contract, unilateral contract, contract for executed consideration, contract for executed consideration. These are the various aspects you should thoroughly understand.